Welcome. My name is David Sokolovsky, and I'm a partner and managing director with the Learner Group. This week is estate planning awareness, and today we want to discuss why it's so important to have a plan in place and how often you should review it if you already do. Today, I'm joined by Wayne Cooper and Melissa Wheaton. Wayne is the estate planning and wealth planning director with the Learner Group and has been practicing law for over 40 years. And Melissa is an estate and wealth planning strategist with the Learner Group and has been practicing law for 19 years. So with that, let's get started. And Melissa, maybe can you talk a little bit about the importance of having a will?
Sure, David. The importance of having a will, well, twofold. If you have minor children, a will allows you to designate a guardian in the event that something would happen to you or your spouse if you're married. And also, when you think about a will, it gives you the opportunity to distribute your wealth how you want to distribute it versus without a will. It would be left to the intestate statutes of the state that you're domiciled in, and you have no control where your wealth, your monies would be distributed upon your death. And I think a big misconception why people do not get a will or an estate plan, they feel as though they haven't acquired enough wealth or assets. Actually, based on some research conducted by caring.com, 1 out of 3 Americans felt this way. And of the 50% of Americans surveyed, although they felt that having an estate plan was somewhat important, only 33% actually have an estate plan. And there's a famous quote that's attributed to Benjamin Franklin. We don't know if he actually said it, but the quote is, "He that hath a trade hath an estate." So people need to understand the importance of a will to distribute those assets, especially here in the state of Florida, where if you have more than $75,000 worth of assets, then without a will, you would not have any control on where that wealth is distributed. It would be left up to intestate statutes.
And Wayne, can you talk a little bit more about what an estate plan is and why everyone should have one?
Sure. So an estate plan is basically a plan to determine how your assets will pass during your death and at your death. Not only does it talk about who will receive those assets, but how they will receive those assets. And by having an estate plan in place, you have the ability to put some safety measures in to protect those assets from future events, whether they be a lawsuit, a creditor claim, maybe a divorce. Assets in that trust would be protected from those types of claims. Now, as Melissa stated, everybody with minor children should have a will to designate guardians. In addition, though, whether you use a will or you use a separate trust, you want to be certain that minor children do not inherit property outright, because minors legally cannot own property. Therefore, if you should die intestate, that is without a will, and you have minor children, they will get a percentage of your estate, and it would go to them outside of a trust. Since they can't own property, the court would then appoint a guardian for that person, and that guardian would have to go in and report to the court every year how the money is spent and how much money was earned and the like. It's just an administrative burden that can easily be avoided. Now, besides going in for minor children, the probate process in itself can be a complicated process. So having a will, we still want to minimize the amount of assets that pass under the will to avoid probate. And the way we do that is by transferring assets during your lifetime to a living trust. And a living trust is a separate document. It's ignored for income tax purposes. You're deemed the owner of all the assets in that trust, but it will be effective upon death to determine how those assets are transferred. a common misconception about trust is children think that if you leave money in trust for them, it's because you don't trust them. And that's rarely the case. We usually leave money in trust for children because we don't trust everybody else, whether it's a creditor who's looking to sue and get a judgment and then collect against those assets, or whether it's a former spouse who wants to get a share of those assets in a termination of marriage. Those type of things can be protected against by using a trust. Okay, so our basic estate plan would include a will, but the will would be a pour-over will, which normally would just take any assets that didn't get into your trust before death and put them into your trust. We would then have the living trust, and then we would have a power of attorney for health care. This is a statutory form. It's called different things in different states, but I'd like Melissa to talk about the importance of the power of attorney for healthcare, especially for parents that have children that are legally adults, but still under their care.
Sure.
Melissa.
And I have an 18-year-old college age son. And because he's an adult, if something happens to him, I would be restricted as far as what information can be shared about his medical condition by a doctor. So one of the things that a power of attorney facilitates is it allows you to designate an agent to act on your behalf to make decisions concerning not only healthcare, but also property matters and financial matters. If you are incapacitated, this person can step in and make those decisions for you. And without a power of attorney of some kind, depending on the state, they're called different things, it would make it very difficult, or in some situations, you'll be forced to go to court, which can become very costly to be appointed as a guardian or conservator.
Right.
So it sounds like, based on what you said, a number of documents, 4 really in total, a will, a trust, a power of attorney for healthcare, and power of attorney for property are the documents that make up an estate plan. And then once you've created that estate plan and have those documents in place, how often would you say, Melissa, that you should review it and make changes?
We recommend that everyone should review their estate plan every 5 years, or if there's been a major update in legislation, then the estate plan should be reviewed at that time.
I would also add that if you have a life cycle event, so possibly a marriage, a divorce, birth of a child, death of a parent, those are always times where you should review your estate plan, because they could affect what your goals are and what you're trying to accomplish with your estate plan.
Well, it's very informative, and obviously there's a lot of detail to go into. So I want to thank Wayne and Melissa, first and foremost, for bringing awareness to the importance of estate planning, sharing some of your knowledge with us and the folks who are watching. And then from a financial, advisor and planning perspective, we've seen, as a result of working with estate planning attorneys, the impact that it can have on family communication, efficient transfer of assets, protection of assets, and overall better outcomes. And so it's been an area where we've seen a significant impact on the overall outcomes with the families that we work. So it's definitely become a more important part of the industry overall. So with that, Melissa and Wayne, we really want to thank you, and thanks for sharing your expertise.
Thank you.
You're welcome. Thank you.